This is a big deal for us. When this ruling came out, we as the Utah Home Builders Association went to our attorney general and said, look, this is a big problem for us. And our attorney general led out and started contacting other attorney generals. Ultimately, we had the National Home Builders Association and 15 other states join in this lawsuit. We did not file the lawsuit in Utah because, like everybody else, they shopped the courts and said, well, which court would be most favorable? And they found that to go to Texas is where it would be best and where they could get a plaintiff. They could get a builder because they have to have a builder say, no, this, when it goes into effect, here's how it will harm me. And they need to be able to show enough to make the court or the case viable for the court to hear it. Talking about the final determination from HUD, from the U.S. Department of Housing. And this is going back, let me look, I've got it all here in front of me. It actually went into effect May 28th of 2024. And this is the ruling that HUD put in place that if you were going to use any of their financing mechanisms, so that would be FHA insured mortgages, public housing funds, USDA rural housing funds or programs, if you used any of those, well, I guess any building, if it's a single family home, it had to be the 2021 IRC or IECC, so the energy code, whether you got it out of the IRC Chapter 11 or if you got it out of the IECC, either way, it had to be unamended, the 2021 energy code. Or if you're doing like the multifamily, then it had to be the ASHRAE Standard 90.1, 2019. That's what we're talking about. So there's a court case that they just had the ruling, and actually I don't have the date when it was, but just recently. This is happening right now. And the court heard that case and they have set it aside. And we made a couple of arguments. We'll talk to him about them here just a little bit that didn't come out exactly the way I had hoped. But the interesting one is the agency, that HUD, argued that the case should just be dismissed. We shouldn't hear it at all because they are reconsidering the rule, which is a good thing, but that they also had extended some of the compliance deadlines. The court said it doesn't matter. We're still looking at whether it's legal or not, and the case was good to be heard. So they heard it. We argued that because regardless that they had delayed some of the deadlines and they're reconsidering it right now, people building and planning projects had to prepare as though that would go into effect because it could switch any time. Ultimately, it was heard. So in the arguments, the one that I wish would have been better is that it was unconstitutional, that they had violated their constitutional rights because they are putting ICC in a position that affects actual costs and commerce and things that are beyond what a private institution is doing, and it's being supported by the government. So the government is saying, hey, ICC, we're using all of your expertise to enforce a law. Ultimately, that did not fly. So it would have been nice to have that. What did finally go is that in Section 109D of their rule, it said that it only goes into effect. It does not have a negative impact on housing. And right within the body of their document, they said that it would reduce housing availability by 1.5%. So within their document, their actual rule and the findings of it went against what they said it was going to do. So the court kind of keyed in on that. They denied HUD's motion to dismiss, said, no, we're going to move it forward. They said that HUD had exceeded its statutory authority and it had conflicted with Section 109. It also rejected the argument that the claims were arbitrary and capricious. Again, that was us saying, well, they've looked at one federal research lab's findings and says, okay, this is how we come up with the numbers, and we disagree with those numbers. We've had other labs look at it. We've looked at actual construction, and we disagree with those numbers. So we said, look, you got to have more science than what we believe is very biased company to do it. And it's the Pacific Northwest National Laboratory, and they do it all on modeling. And over the years, they've won tons of awards for being really big energy advocates. So they have a very biased approach. This is what they stand for. And so they look at it, and you need to factor in all of the other potential things. So anyway, so they did set aside the final determination. Basically, for right now, that whole rule and all of you that have been asking and where are we and what's happening, the court has said it's not legal. They can't do it. The Trump administration is re-examining the rule with the intent to roll it back anyway.